On my left, Professor Tullio SCOVAZZI, Professor for International Law at the Milan-Bicocca University, and Assistant Professor Yurika Ishii from the National Defense Academy of Japan, and Dr. Friedrich Nair from the EU Council Legal Service, and as well Senior Researcher associated to Leuven University. So the second panel is mainly dealing with due regard obligations as they come to the Pacific and economic uses of the exclusive economic zone. And I would like to invite Professor SCOVAZZI with his first intervention on due regard obligations and fisheries in the exclusive economic zone.
Thank you very much, Madam Chairperson. First of all, I wish to thank the organizers of this meeting for the invitation to attend a discussion on such an interesting and sophisticated topic as due regard obligations. Second, as I am a very prolix and sedentary individual, and once I have the floor I go on for 8 hours without interruption, I need a time limit, a reasonable time limit, 20 minutes starting from now. To attach myself to the previous discussion, I would make a few preliminary remarks. Due regard obligation for me is not a question of terminology. We have different wordings in the UNCLOS. Due regard, reasonable regard, particular regard, even also taking into account, which is the most frequently used expression. For me, the meaning is more or less the same. I understand that we could have some nuances which have also a legal significance. But in fact, what is the concept? That we have different rights or interests belonging to different states, and we must find how best to balance those potentially conflicting rights and interests. That's the problem. The exclusive economic zone in particular is more or less an allocation of different rights to different states. So we understand why we have the need to balance that. But this does not mean that all the rights and interests have the same weight. That is very clearly stated in the Chagos Award, and it has been recalled. The tribunal said that due regard obligations should be applied on a case-by-case basis, and the tribunal declined to find in this formulation any universal rule of conduct. So we have to balance different factors, such as the nature and importance of the activities contemplated by the first state and the activities of the second state, and the availability of alternative approach. So there is no universal rule of conduct. The balancing of different rights can have different results. Let me give an example. On the one side, we have the right of the coastal state to fish in its own exclusive economic zone and to grant to others licenses to fish. On the other side, we have the right of other states to engage in military exercises, for example, the testing of weapons, because they think it's belongs to other lawfully activities which are part of freedom of the sea. And we have to balance. In my view, in this case, the right of the coastal state has priority because the other state has to explain why it wants to engage in military activities which can prevent fishing activities precisely in the exclusive economic zone of that coastal state and not on the high seas or in its own exclusive economic zone. So the coastal state, in my example, has priority over the right of the other state. And then there is another remark which is quite important in my view, that not only we have to balance the interest of one state and the interest of another state, also the international community has a role to play. This morning Article 59 has been recalled. In my opinion, it is a magnificent provision in the UNCLOS. In cases where the UNCLOS does not attribute rights or jurisdiction to the coastal state or to other states, the conflict should be resolved on the basis of equity and in the light of all the relevant circumstances, taking into account the respective importance of the interests involved to the parties, as well as to the international community as a whole. So, in our game, also the international community has a role to play. Not only the particular interest of single states, but also the general interest of the international community. And this could be important, especially when the interest of protection of the environment is at stake. So it is a very interesting game which has different players, including the international community. Coming to my subject, the fishing activities in the exclusive economic zone, in the judgment by the International Court of Justice of '74 on the fisheries jurisdiction cases, United Kingdom and also Germany against Iceland. The court had to balance on the one side the right of the United Kingdom and Germany to fish on the high seas beyond at that time the 12-mile limit on the one hand, and on the other hand the preferential rights of Iceland in the area between the 12 and the 50 nautical miles, which at that time were claimed the limit of the fishing zone of Iceland. And the court concluded that both states were under mutual obligations to undertake negotiations in good faith for the equitable solution of their differences concerning their respective fishery rights. And according to the court, this solution, I mean the obligation to negotiate, flows from the very nature of the respective rights of the parties. To direct them to negotiate is therefore a proper exercise of the judicial function in this case. I have some doubt about this view that according to which due regard obligations have more a procedural than a substantive content. I have some difficulties in agreeing on the fact that the court to which the litigants address themselves precisely because they cannot reach an agreement can oblige them to negotiate an agreement. In my view, it is departing from the function of the court, which is to decide a case on the merits. Perhaps the court had some reluctance in engaging in the work of counting and allocating fish to states. This is not the proper function of the court, that the court can rely on experts according to Article 50 of the Statute of the International Court of Justice, and this kind of technical problems can be solved through the resort to experts. So, in my view, due regard obligations have a substantive content, not only a procedural content. If the states concerned are able to negotiate a solution, the problem is solved. If they are not able, the court should be capable of finding a concrete solution to the problem. In the part of the UNCLOS devoted to the exclusive economic zone, the expression due regard is found 4 times in part 5. We have Articles 56 and 58 on the respective relationship between the coastal state and other states. Yes, 10 minutes more. Yes, yes. And then we have Article 60, which deals with the removal of installations and structures, and Article 66 on anadromous species. We can devote some time to Article 60, which has some meaning. It says that the removal shall also have due regard to fishing. What does it mean? It could mean